Sanjay Hegde, can it be said from the government's perspective that here is, I don't want to say a cabal of lawyers, but like a community of lawyers who are used to the system being a certain way, and therefore to protect their own interests, they're taking the position that they are?
There's nothing, listen, most of us lawyers will have armies of other lawyers under us to tell us what to say.
No, but 320 is no longer 320 and 420 is no longer 420. So there's a lot of relearning involved as well.
That's okay. We can learn fast enough. The question is, as Dr. Singhvi put it, a whole host of precedents which define what murder is or what is to happen in a given circumstance. Now, please look at it. When, for instance, I'll give you. When do you file an application for discharge? You file an application for discharge after the evidence is put in, and you say that the evidence doesn't make out a case. Now, what does the new Samhita provide? The accused will prefer an application for discharge within a period of 60 days from the date of framing of the charges. Now, that is some kind of, what shall we say, put the cart before the horse? Or after the horse. The court says that there is material to frame charges against you. After that, you go and file an application for discharge, and then the court gets into that. This is, I think that if they had run their drafts through teams of lawyers, we would have volunteered for national service, saying, boss, look, this is the problem, here is the problem, why don't you come back? It appears that a few consultants were hired. Somebody was told to draft it. Some kind of general consultation happened, and they possibly thought that there were going to be more consultations. But now a half-baked draft has been thrown into the nation's face, and we are told that, look, forget Macaulay, you Macaulay Putras. Macaulay drafted the IPC, therefore it is bad. Sometimes I'm reminded of what Shelley said, that poets are the unacknowledged legislators of mankind. We had a draft, we had the IPC, which was a model, as somebody else said, for several countries. The IPC is common to most of the sections between India and Pakistan, as far as the penal code are concerned, are very common. This is part of our heritage. This is part of the legal system. Yes, procedurally, certain things have been sought to be improved, but even there, I showed you what's happened on the discharge provision.
Okay, Siddharth Luthra, how do you respond to all the criticism that we're hearing? This is some kind of black magic had the government pulling this out without adequate discussion and deliberation, that this is being done in a hidden and opaque fashion. How do you respond to this criticism, and what do you think can be done to try and make the changes palatable and acceptable?
I think these are questions parliamentarians should answer, and it is a debate between different political entities. I am not competent to answer such an issue, but the point is this: to have meaningful reform, there will have to be discussion. I'm hopeful that now the matter has gone to the standing committee, there will be meaningful debate and consideration, and what will come back from the standing committee will be a much improved version. Look, any change in the law, any change in the procedural, substantive or evidentiary law is important for the evolution of a nation's criminal justice system. But I feel that this administration had a golden opportunity and they could have done a lot more. I'll leave it at that.
But Aman Lekhi, some of the things that have been sought to be introduced, for example, witness protection, are changes that the Indian legal system has been clamoring for a long time. And is there a way in which we can implement the reforms which are genuine steps in the right direction and try and address the concerns as well, find a happy middle ground? Is that possible in your view?
No, absolutely. But you don't need to have wholesale a repeal of the existing law, demeaning of their worth, and suggestion that this is a liberating exercise. I have my very serious objection, and I will not in any way hold back on my criticism, like Siddharth is saying. I think this requires all-rounded, comprehensive, and trenchant criticism of the government. As far as reform is concerned, this is not the first attempt at reform. There have been various committees. We have law commissions also in place. We have got judicial determinations wherein the courts have also pitched in, talking about changes that have taken place. To bring about changes, law is dynamic. It's open to reform and interpretation. It is open to modification. There is no objection to that. But the point is, the process has to be measured, and the test is of legitimacy is not just a vote in Parliament. I have got a very strong objection that is concerned. It is reduced to a vote in Parliament, whether through the standing committee method or legislative measures. This is a comprehensive legislation, the core of the penal system. Insofar as the change has to be brought about, the change cannot possibly be through 3 bills surreptitiously brought at a time when we were discussing other issues of national importance. If matters of this import are to be brought, they have to be debated prior and later, not kept in, sent to the standing committee and just kept on the shelf for the time being. It just shows that the purpose is not reform, the purpose is distraction. You are all discussing something which is not the law. We are discussing something which may never be the law. And while discussing that, we are not discussing something which should be relevant to the current situation. So the question I'm putting to myself is, if it's a matter of this importance, why was it presented in this particular manner? Why was it shelved by sending it to the committee? And was the real objective actually reform, or the objective behind that was simply a diversion? Because it seems more of a diversionary tactic than a very realistic attempt at reform.
Okay, Nalini, what happens next? This goes to a standing committee. Does it come back in time for the winter session? Because one of the concerns is whether this will come back before the next general election at all, because then you have the budget session, which is a truncated session, and then there are elections. So do we have a timeline for what happens next?
Well, the government is certainly hoping that it's going to come back in time for the winter session.
But can it, because of the disagreements, the kind of consultation that will be required for bills of this magnitude?
Well, in my opinion, possibly not, because there's going to be a lot of pushback, mainly because there were no consultations that were really held before this law was introduced. So there's going to be a lot of pushback from within the legal community against these laws and against the changes that have been introduced. In addition to that, in case this law is now challenged before the Supreme Court, even if it comes by the time of the winter session, if it's challenged before the Supreme Court and the Supreme Court starts looking into the matter, then it might go on for a much longer time than what we expect for. But the reason why there are certain aspersions that can be cast on the government's intent over here is because there was, like somebody stated, they had a lot of golden opportunity to make changes, especially with regard to very real problems that India has been facing. They could have brought in a law against hate speech, which has become a flashpoint just in the past few months. But we've seen no law on hate speech, despite the fact that they say that they've brought in a law against mob lynching. We see no law on the aspect of grant of default bail, despite the fact that the government acknowledges that prisons are overcrowded. There are a lot of people under trials who are still locked in the prisons.
You know, the reason I set up this roundtable is to pick some of the minds of the finest lawyers on where they stand on the current laws. Remember, we also reached out to a lot of the lawyers in the BJP. None of them for this show agreed to come. However, as this debate builds, hopefully we will hear from the government. They can explain their perspectives. For the time being, you've heard from the likes of Aman Lekhi, Sanjay Hegde, you've heard from Siddharth Luthra, Abhishek Singhvi. Nalini and her team will track these changes very, very carefully. This requires a conversation because these are massive changes. They impact every one of us. They impact the Indian legal and judicial system as it stands. And as you heard, a lot of the past judgments and the context in which that they've been given, what happens to that going forward. So a lot to chew on. These are big changes. Can they be pushed through? The government has sent this to a committee, so it will be debated. We'll track what happens there. I want to thank all of you for joining us on the News Track.